Hello, everyone, and welcome to Uncivil Law. I hope you're having a wonderful day. And first of all, a minor announcement. I just passed 8,000 subs earlier today. So I'm pretty excited about that. A little milestone victory for me. I will take it. And we are here with the Supreme Court's decision from earlier today on the DACA, the Dreamers, the deferred action against those who were here illegally brought by their parents or other guardians and were given a deferred status in terms of being deported. The United States Supreme Court has issued its opinion on this in terms of whether the Trump administration can repeal the DACA deferment that was put in place by the Obama administration. Long story short, yes, in principle, the Trump administration can, but the Trump administration did not follow the procedures of the Administrative Procedures Act. Now, I'm a little bit dubious on this decision because I think Justice Thomas, in the dissent, has it better. Why? Because what the Obama administration did was essentially create a program, but they didn't do it through a formal rulemaking process. They did it essentially through a memorandum and internal policies, but they didn't do it through formal rulemaking. And so Justice Thomas in dissent says, and I think he might have the better end of this one, that which was not created with formal rulemaking does not have to be abolished through formal rulemaking, and it leads to some perverse incentives and perverse results going forward. Because what it seems to suggest, according to Justice Thomas, and I think he has a point, is that future administrations can just create anything into existence from nowhere, and now apparently we're giving deference to that. So forget Chevron deference. We're on to a whole nother realm of deference. At least with Chevron, we had rules. Now we don't even have rules. Now we're just abolishing. Now we're just creating stuff out of thin air. So we have a new Chevron deference, I guess, and this is a thing that's happening. So we're going to read this and try to figure out what is going on. Very exciting. All right. So we are in Department of Homeland Security versus Regents of the University of California. So the University of California complained on behalf of itself and also on behalf of its students that, their students would become deported, the students who were not here legally, but let's press on. All right, so we're going to read the syllabus and try to understand this legally. In 2012, the Department of Homeland Security issued a memorandum announcing an immigration relief program known as the Deferred Action for Childhood Arrivals, DACA, which allowed certain unauthorized aliens, non-citizen, non-residents, right? Unauthorized aliens and other people, in other words, illegal. Unauthorized aliens, in other words, illegal aliens. Because they weren't authorized by law. Yeah. So which allowed certain unauthorized aliens who arrived in the United States as children to apply for a 2-year forbearance of removal. So the forbearance was only supposed to be for 2 years, and that was 2012. And I think it's been more than 2 years since 2012. I don't know, I'd have to check. But yeah, and it's still going. Those granted this relief become eligible for work authorization and various federal benefits. Some 700,000 aliens have availed themselves of this opportunity. 2 years later, the Department of Homeland Security expanded the deferral program, eligibility, and created a related program known as Deferred Action for Parents of Americans and Lawful Permanent Residents, DAPA. So our initial idea is let's give cover to the children who are brought here as children and don't have any responsibility for that because they are brought here as children. And let's give them some deferment so they can finish their education and whatever. And okay, and then 2 years later, they said, well, what about the parents, though? It's like the parents who knew what they were doing because they were adults. Yes, those. Well, we can't deport the parents because then the children would be without the parents because we deported the parents. But the parents knew what they were doing, right? So we should deport them. No, because then the kids would be alone. So we have to let the parents stay too. So essentially, we created a back end around the immigration system. That's just super positive. If implemented, that program would have made 4.3 million parents of the United States or lawful permanent residents eligible for the same forbearance, which is roughly about It's a little bit more than 1%. I'd have to do my math, but there's 350 million, give or take, 4.3 million. So this is a little bit more than 1% of adults. So we are going to increase the size of the United States by a little bit more than 1% overnight without congressional authorization. Texas, joined by 25 other states, secured a nationwide preliminary injunction barring implementation of both DACA and its expansion of DAPA. The Fifth Circuit upheld the injunction, concluding that the program violated the Immigration and Nationality Act, which it absolutely does, because there's actual laws in this. And at least in theory, and my many, many issues with Chevron, for anyone who follows this channel, knows, right? I'm under the view that Congress passes laws. And the administration should not be allowed to just create regulation out of nowhere and then get to interpret its own regulation and change its mind and then be giving binding authority. And now we're one step worse, because not only do we do that if we create a regulation, we do that just for memos that just exist. They weren't created with APA, but apparently now we have to repeal them with the APA. That's a strange result. This court affirmed by an equally divided vote, and the litigation then continued into district court. In June of 2017, following a change in the presidential administration, the DHS rescinded the deferral program for the parents, citing, among other reasons, the ongoing suit by Texas and new policy priorities, such as, for example, perhaps, enforcing the immigration laws of this country. That September, the Attorney General advised the Acting Secretary of Homeland Security, Elaine Duke, that DACA shared DAPA's legal flaws and should also be rescinded. Yes, I think this is correct. It does have legal flaws because it wasn't created through a formal rulemaking. And also, if it had been, I don't think it should be legal anyway because it would be in violation of the law. But we all know how much deference Chevron gives. But anyways, yes, the Attorney General has a pretty solid point, it seems to me. Taking into consideration the Fifth Circuit and the Supreme Court rulings and the Attorney General letter, Duke decided to terminate the program. She explained that the Department of Homeland Security would no longer accept new applicants, but the existing DACA recipients whose benefits were set to expire within 6 months could apply for a renewal. I'm not sure why, because they were only ever guaranteed 2 years at a time. So why they were allowed to apply for a renewal, I don't know. We only guaranteed you 2 years. And assuming you have a legitimate expectation interest in this illegal program, so assuming you have a legitimate interest in that, your interest was for what was promised to you, which was 2 years. So if we say, oh, you can't apply for renewal, then we're not taking away anything because you were never guaranteed that to start with. So we say, okay, well, even then, we'll let you apply for renewal, even though it doesn't seem like we should have to. You weren't ever guaranteed tomorrow, so I'm not sure why we have to continue to provide you tomorrow, but okay. For all other DACA recipients, previously issued grants of relief would expire on their own terms, which again, I'm not sure you have to because it's illegal. But it's like, well, maybe you have an expectation. You have an expectation, and so we'll give you as much as you were promised and nothing more. So, that seems more than fair, but the Supreme Court seems to disagree. Several groups of plaintiffs challenged the Secretary's decision to rescind the DACA, claiming that it was arbitrary and capricious in violation of the APA. Okay, no, this is apparently where the Supreme Court is going. It's arbitrary and capricious in violation of the APA. Well, I might agree with you if DACA or DAPA was created with the APA. Then I might agree with you. But the idea that you have to follow a procedure to rescind something that wasn't created with that procedure seems really odd. Really odd result. It's like it wasn't created using a procedure, but we have to repeal it using that procedure. A procedure, incidentally, that isn't authorized by law. A procedure that we just invented out of nowhere. And now we have to give this the same deference as though we went through formal rulemaking. Query why an administration would ever go through formal rulemaking ever again, since you can apparently just do it by writing a letter, which is way easier. So we've completely undermined the Administrative Procedures Act because what's the point? But oh well. The district courts in California, New York, and the District of Columbia ruled for the plaintiffs. So, yeah, these courts said, yeah, the administration can't do that. Each court rejected the government's arguments that the claims were unreviewable under the APA, which kind of seems like, yeah, and that the Immigration Service deprived the courts of jurisdiction, which it might, because the Immigration Nationalization Act, like to have jurisdiction in courts, it is often the case in case of administrative agencies that you have to exhaust an administrative process before you can get to court. So yes, the Immigration and Nationalization Act may very well deprive a court of jurisdiction, especially if there's some sort of internal review process you're required to go through first. This is basic federal law. In general, you have to exhaust your administrative remedies before you can talk about legal remedies. So it might very well be the case that the Immigration Act deprived the jurisdiction of the courts. These courts didn't see a problem with that for some reason. In Regent and Balata Vidala, the district courts further held that the equal protection claims were adequately alleged. Equal protection of the law. You know, this is a very, very minor and kind of somewhat technical point, but there's a lot of case law that suggests the constitutional guarantees really only apply in their full form to lawful residents of the United States, citizens and green card holders, and doesn't really apply to anyone else, right? So there's that case, Velada, I can never quite remember the name of the case. It has a really, Velada, I can't quite remember, but there's a case that basically suggests that the constitutional guarantees only apply to those in privity to the American Constitution, which is we the people and the lawful permanent residents, and may not apply especially to those who are here illegally. So query whether or not they have an equal protection guarantee in the first place, but we'll look past that issue. The district court in NAACP took a different approach. It deferred ruling on the equal protection challenge, but granted a partial summary judgment to the plaintiffs on the Administrative Procedures Act claim, finding that rescission was inadequately explained. I'm not sure why we're required to adequately explain it, because we'd only be required to adequately explain it if we were required to adequately justify it in the first place. And the only reason we'd be required to adequately justify it in the first place is if we had a statute that told us that. For example, the Administrative Procedures Act. If we wanted to create formal rulemaking, yes, we'd have to do all kinds of stuff to make that happen. And if we want to undo it, we have all kinds of stuff to make it happen. But here, we didn't provide a sufficient rationale. I'm not sure why we were required to, but okay. The court then stayed its order for 90 days to permit the Department of Homeland Security to reissue a memorandum rescinding DACA, this time with a fuller explanation of the conclusion that it was unlawful. Which doesn't seem particularly hard, because here's my back-of-the-envelope legal argument. My back-of-the-envelope legal argument is DACA is unlawful because even assuming the President of the United States can defer prosecution and can do it en masse, which you could view as a privy of prosecutorial authority. So here's the best argument for the Obama administration, it seems to me. So if you asked me, the best argument for the Obama administration, what they did is essentially deferred prosecution. And it went that way too, right? And we've covered this recently in the Michael Flynn case. You can't force the federal government to prosecute. So what you could view, what the Obama administration did is, it's a deferral letter. It's essentially a deferral letter. It's a decision from the prosecutor, the chief prosecutor of the United States, the president of the United States, who can give orders to the prosecutors because they all work for him. So it's an order from the president of the United States in his role as chief prosecutor, chief law enforcement officer. It's a deferral letter. And what it basically says is, notwithstanding our ability to prosecute, we are going to not prosecute. And we're not going to prosecute for 2 years. So that's the best argument for the Obama administration, what they did. It's a deferral letter from the Department of Justice, essentially. It comes from the president, but it's the Department of Justice, which, again, the president runs the Department of Justice, so, that's fine. All right, great. So that's a deferral letter. All right, that's fine. Well, here's what happens. Unless there's some statutory reason or other reason, like double jeopardy or something, a different prosecutor can change their mind. And so prosecutors are very typically elected. Not in the case of the United States prosecutors, they're all appointed. So the president appoints all the U.S. prosecutors. But in states, it's very common for the prosecutor, to be elected. The ones under the prosecutor are often appointed by the prosecutor. But it's not unusual for the prosecutor to be appointed. The prosecutor of the jurisdiction, the highest prosecutor of the jurisdiction, to be elected. And then his subordinates are appointed. But if you get the prosecutor, they can have different policies as long as those policies are in line with law. So the first prosecutor said, well, I don't want to prosecute these cases. These aren't my priorities. Okay. A new prosecutor just got elected and he said, you know what? I have different priorities than the other guy, and I want to prosecute these cases. So as long as there's not some sort of double jeopardy, or as long as the prosecutions are valid under law, as long as there's not some sort of other reason that, maybe they're time barred, because of time issues. So maybe there's some reason that these prosecutions can't be made. But, absent something like that, the new prosecutor should be able to come and say, yeah, I'm going to prosecute those cases. You're still violating the law. You're still violating the law. So I can come in and prosecute those cases, especially if you're in continuing violation of the law. Because if it's something that happened in the past and it was discrete, so then you could maybe make a reliance interest, right? I broke into the store as a single event. The prosecutor decided not to prosecute me. And even though I'm within the time periods that would allow the prosecutor to prosecute me, maybe somehow I have a reliance interest in that deferral because I've moved on with my life and so forth and so on. So even then, maybe you can make an argument, although I don't think that would work. But what makes this particularly weird is that there's an ongoing criminal violation because it's not a discrete event. The illegality of it is continuing and ongoing because the people are here illegally in violation of the law. They're unauthorized aliens. They're here illegally. So it's not just I committed a crime in the past as a discrete event for which I have been given a waiver, and so I have a reliance on that, which you could make an argument, although I don't know that works, but at least you would have one. It's I'm in continuing violation of the law. I'm still violating the law because I'm here unauthorized and I'm not allowed to be. And somehow I have a reliance interest on that on an ongoing basis. I don't get this at all. And if the new prosecutor wants to say, you know what, you're still breaking into stores every day, and I've decided, I don't want to defer anymore, and I'm now going to start prosecuting me. I don't see how you can turn around and say, that's not fair. I've built my whole career on breaking into stores. I should be allowed to continue breaking into stores. As the prosecutors say, well, I don't know what to tell you. Please stop doing that. And apparently, the United States Department of Justice, in a somewhat comparable scenario, has said, that's not fair. I want to continue breaking the law. And the Supreme Court has said, you can continue breaking the law. And the Trump administration didn't do their due diligence in proving why they can prosecute you for something that's clearly illegal, for which you're in continuing violation. And a new prosecutor has been elected, and there's not a double jeopardy problem. There's not a time bar problem. There's not a reliance problem because we're talking about ongoing violations. So all those considerations seem to go out the window. But the Trump administration was supposed to go through the Administrative Procedures Act, even though the Trump administration has said, okay, we've decided we want to start prosecuting these cases now because they're in violation of the law. But we're not allowed to do that. This is strange. Two months later, the secretary's successor, Secretary Nielsen, responded to the court order. She declined to disturb or replace the rescission decision. Yeah. And instead explained why she thought her predecessor's decision was sound. Seems plausible. In addition to reiterating the illegality conclusion, which either the original order was illegal, and even if it's not, we can just rescind it because we're the prosecutor now, we get to do that. She offers several new justifications. The government moved for district court to reconsider the light of these additional explanations, but the court found the new rationale failed to elaborate meaningfully on the other rationale. Okay. The government applied the various district court's decisions to the 2nd, 9th, and 6th D.C. circuits, respectively. So yes, we're applying different things in different places, which is always annoying when you're the federal government because you have different courts acting, and so we have to apply different rules in different places, which is a little bit annoying. While these appeals were pending, the government filed 3 petitions for certiorari before judgment. Following the Ninth Circuit's affirmance in Regents, the court grants certiorari. Okay, just a minor technical point there. So a grant of certiorari before judgment. By judgment here we mean the judgment of the Court of Appeals, not the district court. So the district courts have rendered their judgment, but the Court of Appeals haven't all rendered their judgment. And the Ninth Circuit apparently did in their case, but the other cases haven't made it through the system yet. And so the Supreme Court could defer, waiting for the lower courts of appeal to render their decision. But the Supreme Court says, yoink, we are now the Court of Appeal, because we can do that, because there's a rule for that. So yes, we are now the Court of Appeal straight from the district court straight to us. One and done. We're going to do this all at the same time, which given the related subject matter seems like a reasonable thing to do. Why wait for the various district courts to get around to it? Instead, just resolve it yourself. Something the Supreme Court can do, something they don't do a lot. Incidentally, they've done it more during the Trump administration than typical, and the Trump administration asks for it more than typical. I'm not sure what that really says about anything. The rules allow for it. It's been something that has been more or less rarely done by past administrations, but there's nothing in the rules that requires it to be rare, except that the Supreme Court rules suggest that it should be rarely granted, but they ask for it a lot more. The Supreme Court's granted a lot more, so I don't know. But this seems like a perfectly reasonable use. We have one Court of Appeals that's rendered a decision. We've got district courts that have rendered other decisions in other places. So yoink, we'll have all that, and let's just do it now. Okay, great. So now we finally get to the judgment. Held. The judgment is vacated. Okay. So we have about stuff that's vacated and remanded, so technical stuff. So let's go past that thing and just go to the actual merits of the decision. All right. The Department of Homeland Security's rescission decision is reviewable under the Administrative Procedures Act and is within the court's jurisdiction. Okay. The Administrative Procedures Act's basic presumption of judicial review of agency action can be rebutted by showing the agency action is committed to agency discretion by law. In Heckler, this court held that this narrow exception includes an agency decision not to institute an enforcement action. So the original decision was not subject to the APA. That kind of makes sense because it's prosecutorial discretion. So the APA is the thing that allows you to go after administrative agencies at large. It is the thing that allows administrative agencies to create rules and formal rulemaking. It's also the thing that allows you to go after an administrative agency because they have to follow certain protocols, and it gives people an opportunity to be heard and redress and all that good stuff. And if you don't do those processes, it gives you an opportunity to attack what the administrative agencies does. So one of the things it doesn't allow review of is a prosecutorial deferment, which makes sense because the idea of a prosecutor deferring is pretty well baked into U.S. history, for better or worse. The prosecutor can just decide not to do it, and they don't have to go through any formal process for that. So the Supreme Court says, yeah, we've previously held that a deferral decision to not prosecute is something that doesn't require review, which makes perfect legal sense because the prosecutor's authority to defer prosecution has always been very, very wide. So that makes sense. The government contends that DACA is a general non-enforcement policy equivalent to an individual non-enforcement decision in Cheney, which I would say it is. Yes. The fact that it applies to a lot of people is kind of irrelevant. So yes, instead of writing one person, we're deferring prosecution on you. We effectively wrote 5 million people and said we're deferring prosecution on you. Do I think that changes anything? I do not. It's 5 million rather than one, but it's still a deferral decision. So I don't think it changes the analysis, but it looks like the Supreme Court's about to disagree with me. So, okay. But the DACA decision did not merely decline to institute enforcement proceedings. It created a program for conferring affirmative administrative relief, which is a problem because then that actually cuts the other way. So yes, you're kind of undercutting your own logic here, Supreme Court. If all it did was a deferral decision, then sure. Then that would have been fine. It's just a prosecutorial discretion. No big deal. That's fine. Whether it's 1 million people or 5 million people, that's fine. If it's the Department of Justice and they want to issue a memo, as they did in the Obama administration, which I still think it applies, but they issued a memo saying we're not going to prosecute any pot cases that are in perfect compliance with state law. That impacts millions and millions of people. So yeah, you want to issue a decision that impacts lots of people or one person, that's fine, no problem. But so you don't have to go through the APA. But here you're saying, well, it didn't just do that. It also created some affirmative stuff, which suggests that it had to go through a rulemaking process, because if it was just deferral of prosecution, yeah. But if it's giving you the right to apply for stuff and some sort of affirmative relief, a prosecutor can't do that. A prosecutor can decide not to prosecute. A prosecutor can't give you the right to like apply for programs and stuff like that, just out of thin air. So it seems to me like that means the original DACA was at least illegal in part. It was presumably legal in part to the point where it deferred prosecution, and it was illegal in the part where it was creating affirmative rights, because those things were not done through a formal rulemaking process. They were just done on a whim with a memo. I'm not sure how you're able to do that. Therefore, unlike the non-enforcement decision in Cheney, DACA's creation and its rescission is an action that provides focus for judicial review. Yeah, I'm on board with that because, again, you can't force the prosecutor to not prosecute. So if all it was a memo saying we're not going to prosecute, you can't get review of that. You can't force the government to prosecute. So if it was a memo saying we're not going to prosecute, what this says is we're not going to review it. Right. But it didn't say just that. It said other stuff, which means we can at least evaluate the other stuff. We may not be able to review the non-prosecution element, but we can review the other stuff element because it's not a non-prosecutorial decision. It's not within the prosecutor's power. Yeah. In addition, by virtue of receiving a deferred action, 700,000 DACA recipients may request work authorization and are eligible for Social Security and Medicare without formal rulemaking. I don't know how that works. You can't just create this out of nothing. But apparently you can somehow. We are now doing administrative law on the equivalent of a back of a napkin. That's super positive. Access to such benefits is an interest the courts are called on to protect. Sure, if they were legitimate and lawful interests, yes. If not, then not so much. DACA's rescission is thus subject to review under the APA. What? If the rescission is subject to review under the APA, the original thing is also subject to review under the APA. So are we going to at any point review the original thing? If the repeal is subject to the APA, the original thing was subject to the APA. This is part of Justice Thomas's dissent. He's like, the majority doesn't even attempt to illustrate this problem, and they don't seem to. Yeah, I'm with Justice Thomas on this one. If it was just a prosecution discretion, the executive giveth and the executive taketh away. No problem. If it's just a deferral, the executive giveth and the executive taketh away. But it's not that. It's creating entitlements to apply for jobs, entitlements to get Social Security, Medicare, Medicaid, and we're doing that assuming we have the right to do that at all, which, again, I have massive issues with that under the because again, you can't do through rulemaking what's illegal. So even all the power under the Chevron deference, again, theoretically, you can't do what's against the statute. So even with Chevron deference, I'm not sure that you can just create a right to benefits such as Social Security, Medicare, and the right to work, because I think it would be in violation of several statutes. For example, the immigration statutes, the Social Security statutes, the Medicare statutes, and so forth and so on. So first, I question whether or not it's lawful to do it with rulemaking. But pushing that issue aside, assuming it is lawful to do with rulemaking, you didn't do it with rulemaking. So the executive giveth with a non-rulemaking, but they can only taketh away with rulemaking, even though it was unlawful in the first place. Because if it's lawful for the government to just do it with a memo, then it should be lawful for them to undo it with a memo. But they didn't. Okay. No, this does. Yeah. You see, my brain is like trying to reconcile these irreconcilable positions, and I'm running into logical paradoxes. The two jurisdictional provisions of the INA invoked by the government do not apply. Some law which bars review of claims arising out of actions or proceedings to remove an alien is inapplicable, whereas here, the parties do not challenge any removal proceedings. That's a very colorful way of coloring that, because, yeah, there are no removal proceedings because they've been deferred. Of course there aren't. A decision not to commence proceedings, and a rescission is not a decision to commence. Okay. This is an interesting conclusion by the Supreme Court. The rescission is not a decision to commence proceedings, adjudicate cases, or execute removal orders. How are you coming up with that logic? There was a defense, there was a memo that said we're not going to prosecute these cases, and then the Trump administration says we'd like to withdraw that memo, and the Supreme Court says, well, that isn't a decision to commence proceedings, adjudicate cases, or execute removal orders. I don't know, man. It looks suspiciously like it might be one of those three things. You know, the Obama administration said we wouldn't like to do this, and the Trump administration said we'd like to revoke this rule. And the Supreme Court says, well, that's not saying you're going to commence proceedings by withdrawing the DACA. That is the thing that's preventing you from conducting proceedings. So you're not saying you want to conduct proceedings. You only want to withdraw the DACA, which has nothing to do with removing people. Okie doke. DHS's decision to rescind DACA was arbitrary and capricious under the APA. You might be right. I'll give you a point, U.S. Supreme Court. You might be right. The Trump administration probably did not dot the I's and cross the T's of the APA. Yes, you're probably right. So yes, it probably is arbitrary and capricious within the meaning of the APA. Yes. But you know what else? What was arbitrary? You know what else was arbitrary and capricious within the APA? If the Trump administration creating this or revoking this out of nowhere is arbitrary and capricious within the meaning of APA, you know what else is arbitrary and capricious within the meaning of the APA? When the Obama administration created it, that would be arbitrary and capricious because they're doing it out of nowhere without the sufficient. The Administrative Procedures Act creates rules on how, like, it's a rule for rules. It's a rule for rules. It's a rule on how to create rules, rescind rules, on how to do things in administrative and how not to do things in administrative. So if you didn't have to follow the APA in the first place, why do I have to follow the APA now? And if I have to follow it now, why didn't I have to follow it in the first place? If it were a straight up deferral of prosecution decision, then yeah, I can just create it out of nowhere. No problem. I can defer prosecution out of nowhere. I don't need to do it in a formal memo or anything else because prosecutorial discretion goes pretty damn far back. It's well-baked. It's a well-baked concept. So the APA does not apply to prosecutorial discretion. Great. So I, as a prosecutor, can giveth and I can taketh away, and I don't need to go through any formal process to do it. I can just do it on the back of a napkin, no problem. This is fine. Yeah. And if I'm undoing it, you might have arguments, especially if they're for discrete elements in the past and all the stuff I earlier said, right? So yeah. But if I'm trying to now, on top of that, give you affirmative rights, like you can apply for work and you can get Social Security and you can get Medicare. Wait a second. Why do I, as a prosecutor, have the right to give you these things? I don't have a right to give you these things. My ability as a prosecutor is to not prosecute you. My decisions are I can prosecute and I cannot prosecute. That's about it. And I'm saying, okay, now you get Social Security. How's that within my realm as a prosecutor? I don't know. So the Trump administration, sure, what they did was arbitrary and capricious in repealing it. How it does not follow that the Obama administration in creating it was not also arbitrary and capricious because they didn't come anywhere close to following the APA's rules in creating it, I don't know. So I have no idea how it's possible for the Trump administration to be arbitrary and capricious within the meaning of the APA, which they almost certainly are, without the Obama administration also being arbitrary and capricious within the meaning of the APA. Yeah, they just created it out of nowhere like magic, which is not something the APA really allows you to do, except in deferment decisions. And the Supreme Court just said this is not merely a deferment decision, which it's not. So yes, the Trump administration is arbitrary and capricious, but you know, the next logical step of that is so was the Obama administration, therefore the whole thing is invalid. And to the extent it has any validity, it would only have validity for some limited purposes. Okay, yeah, all right, let's press on. Let's press on, because it makes my brain hurt. In assessing the rescission, the government urges the court to consider not just the contemporaneous explanation offered by the assistant secretary, but also the additional reasons supplied by the other secretary. Judicial review of an action is limited to the grounds the agency wrote when they took action. That is true. Yes, you are correct. You are correct, Supreme Court. This is well-honed administrative law. Yes, the administrative agency cannot just invent new grounds on the fly. You're correct. They're stuck with the grounds that they had when they came up with it. And if those grounds aren't sufficient, then sure, the Trump administration loses. But you know who else loses? Yeah, okay. If those grounds are inadequate, a court may remand an agency to offer full explanation for the reasoning at the time of the action. Okay? Or to deal with the problem afresh by taking a new action. Okay, yeah. So if an administrative agency is bound by the APA and they come up with this, incidentally, was the same problem that the Trump administration too ran into with the census. Although with the census decision, it made way more sense than this. Way more sense. Because yes, when Trump was trying to add citizenship to the census, there was he didn't follow the rules of the APA. Yeah. He didn't do what he was supposed to do in the APA. So, I thought the decision in the census case was probably legally right. Trump is required to follow the rules of the APA. If you're creating a new thing, there are rules for how to do stuff. Yeah, there are rules for how to do stuff, and Trump didn't do those things. So yes, the Trump administration could have added the census question about citizenship. They just didn't do it the right way. And I had no problem with that because we're just applying the law. The Administrative Procedure Act is a law. And they didn't follow the right steps in promulgating that question. So the Supreme Court, I think, made the right decision in the census case. The Trump administration didn't follow the APA. All right, I'm on board with that. That's fine. However, I'm even on board with the idea the Trump administration didn't follow the APA in rescinding this. They didn't. However, that presumes that the thing that the Obama administration did was proper, such that the Trump administration should be required to follow those steps. So if the Obama administration had done this through formal rulemaking or some sort of other legal process, instead of just doing it on the back of a cocktail napkin, then yes, you would be right, Supreme Court. It would hold. Yes, the Trump administration would be changing something that was lawfully created with an unlawful process. And the question being taken off the census so many moons ago was done through a legal process. So yes, when they took the question off the census, they followed a legal process. Yeah. And so if you want to undo that, you have to follow a legal process. You didn't do that, question struck. Okay, great, no problem. I understand that. But what I don't understand is we've created DACA. We've created deferment, totally legal, and we've also granted these people work status and the ability to get Medicare and Medicaid and Social Security. How are we doing that? How are we doing that lawfully? I have no idea. The Supreme Court doesn't say how we're doing that lawfully. Did we do a formal rulemaking? No, we didn't do any of those things. But now we're required to repeal it using a process that it wasn't used to create in the first place. And okay, yeah, it makes my brain hurt. I can't deal with the logic. The logic hurts my brain. I can't make the logic work. Because the secretary chose not to take new action, she was eliminated. She was limited to elaborating on the agency's original reasons. Only if the APA applies, which again, if it does, then we have an underlying problem we're not going to address in any way. But her reasoning bears little relationship to that of the predecessor and constitutes primarily imposed post hoc rationalization. Yeah, that would be fine. I would agree with you if we were under the APA. But if we're under the APA, then the Obama administration was under the APA, and okay. The rule requiring a new decision before considering new reasons is not a formality. Yeah, it serves an important administrative law value by promoting accountability to the public, ensuring confidence. The reasons given are not simply convenient and facilitating order over review. Yeah, we've given these administrative agencies all the power in the freaking world because Congress can't be bothered to law. So since Congress can't be bothered to law, we've given the administrative agencies all the power in the world. Now, it's not quite so bad because we did, through the APA, create a whole bunch of processes that are designed to create review and rulemaking and stuff like that. And yes, we have a lot of power in rulemaking, and we can change our mind and see, for example, Chevron and Hour, and oh my God. But, it could be worse. It could be worse because we do have to follow a process, even though we can kind of do what we want. But now we don't even have to do that. Yeah. Chevron is dead. Chevron is dead. Long live Department of Homeland Security versus Regents of California. Yeah, which, given how we do case names normally, we would refer to it by the second name because Department of Homeland Security wouldn't be distinct enough. So I guess Chevron is dead. Long live University of Regents of California. That's just super. That's great news. Thanks. Each of these values would be markedly undermined if the court allowed the Department of Homeland Security to rely on reasons offered 9 months after rescission. Yes, if we were under the APA, I'd be on board. But, I kind of got off the train a little bit ago now. So, yes, if we were further along on the track, you'd be right. But I got off like 3 stops ago. So, okay, this is all interesting and stuff. But I got off the train a couple of stops ago. So, yeah. Acting Secretary rescission memo failed to consider important aspects of the problem before the agency. Sure. Although Duke was bound by Attorney General's determination that DACA is illegal. Wow. Wow, that's a hell of a predicate. Okay. Wow, that's a hell of a predicate. All right. So, just so we're all on board here with keeping up in law world, the Attorney General said, hey, this is illegal because it is. And the Department of Homeland Security is bound by that decision. And so going on that basis, they are going to process forward. So yes, like the Supreme Court is saying this like it's a throwaway line. They're saying it like it's a throwaway. Although the Department of Homeland Security was bound by the Attorney General's determination of illegality, you say that like a by the way. That's not really a by the way. That's kind of an important detail. Yes, the Attorney General has said it's illegal, and that's exactly why they didn't do the formal rulemaking, because it wasn't required, because the Attorney General was right. Are we going to address the Attorney General in any way? I'm somehow doubtful. Are we going to say why the Attorney General's determination was wrong? That'd be great. Are we going to do any of those things? Doesn't look like we are. Okay, that's fine. Let's just completely ignore that and just treat it as an aside. So we'll say it the way the Supreme Court probably wanted it to be said. So what I said is, although the Attorney General said it was illegal and they're bound by that decision, but I said that, with emphasis. So let me say it the way the Supreme Court probably wants me to. Although the Attorney General said it was illegal, and the Department of Homeland Security said it was bound by that. We'll just kind of whisper it because it's not important. Not important anyway. So, although there's this niggling little detail that we're not going to discuss any further, deciding how best to address that determination invoked important policy choices revoked for Department of Homeland Security. Wow. Why? If it's illegal, then we can just kind of like enforce the law. That might be a good thing to do. Acting Secretary Duke plainly exercised discretion in winding down the program, but she didn't appreciate the full scope of her discretion. Okay, that's an interesting idea. So we, the Supreme Court, are going to try to say, well, the real problem is the Secretary used discretion in winding it down. And that had to go through rulemaking, that determination. If the Secretary had just cut it off like a light switch, then maybe that'd be one thing. But what the Secretary did to screw this up was actually trying to wind it down. So, it's illegal, but there's a bunch of people here who are being impacted by this. So, I'm going to attempt to wind it down, but I didn't consider that in enough detail. So my charity is being used against me. This is an exemplar of, there's no right to, what you do that's right will hurt you. So apparently what I screwed up as the Secretary of Homeland Security, apparently what I screwed up was being merciful. If I just turned it off and just gone straight to I'm starting to arrest people because it's illegal, then that would have been fine. But what I said is, there's a bunch of people here who are relying on this, even though it's crap. And so I'm going to come up with a wind down decision. And I had to go through formal processes to do that. Okay, Supreme Court, let's go with that premise. That's an interesting trick. So the very thing I did that was wrong, apparently, as the Secretary of Homeland Security, the very thing I did was wrong, was doing this in a merciful wind down instead of a brutal light switch like fashion. That's where I screwed this up. Sure, let's go with that. The Attorney General concluded that the legal defects in DACA mirrored those the courts had recognized in DAPA. Yeah, they definitely have the same legal problems. The Fifth Circuit, the highest court to offer a reasoned opinion on DAPA's legality, found that DAPA violated the INA. Okay. So not only did the Attorney General reach the conclusion that DAPA was illegal, a court reached the determination it was illegal. The Fifth Circuit Court of Appeals. So the Attorney General was apparently mistaken to rely on the decision of the Fifth Circuit Court of Appeals or something. And the Department of Homeland Security was also wrong to rely on the Attorney General's reliance on the Fifth Circuit Court of Appeals, which found it to be illegal. And they were also wrong to try to wind it down rather than just cut it off like a brutal light switch and try to show some sort of mercy and compassion. Okay. Yeah, that's okay. Okay. Again, we're saying this like it's a throwaway line. It's not really a throwaway line. It's kind of important. The Fifth Circuit, the highest court to offer a reasoned opinion on legality, found it to violate the law, but, let's ignore that detail, because it extended eligibility for benefits to a class of unauthorized aliens. Yeah. I mean, I don't have to read the Fifth Circuit Court of Opinion to be like, yeah, that sounds right. Yeah, it wasn't just a deferral decision. It's let's give benefits to people, benefits that are not authorized by law. And the Fifth Circuit says no. It's like, do you even have to read the Fifth Circuit Court of Appeals decision to know that that's the right decision? You do not. That's a little bit much. What the prosecutor can do is say, I'm not going to prosecute you. What the prosecutor cannot do is say, you get a car, and you get a car, and you get a car, and everybody gets a car. Okay. But the defining feature of DAPA and DACA is the Homeland Security's decision to defer removal. Yep. Apparently where I screwed this up as the Secretary of Homeland Security, apparently my critical mistake was trying to wind down this disaster show in a way that didn't create a major crisis. And apparently that was bad, and I shouldn't have done that. I'm very sorry for my wind down efforts. I'm very sorry I didn't just immediately turn off the light switch and actually tried to deal with this in a way that was measured and provided some sort of compassion. I'm very sorry that I did all those things. That was obviously a mistake. That's my bad. Wow. The defining feature was the decision to defer removal. That was a mistake. And the Fifth Circuit carefully distinguished that forbearance component from the associated benefits eligibility, which they are very distinguishable. Yes. One is within the prosecutor's right and one is not. Yes. Limiting benefit eligibility while continuing forbearance thus remains squarely within discretion. I'm not sure how it remained within discretion. The prosecution discretion was yours the whole time, and yes, you could have changed your mind on that. I'm not so sure about the benefits thing, and to the extent it was, I made a mistake by trying to deal with it in a measured way. Apparently, that was a bad thing to do. This is one of the weaker Supreme Court opinions I've read in a while, in case that isn't coming glaringly through. It's like, yeah, I mean, this doesn't make sense. This is... I split with the Supreme Court on this one, man. Jeez. That reasoning repeated the error of Motor Vehicle Manufacturing Association, treating a rationale that applied only part of a policy as sufficient to rescind the entire policy. That's a little bit different there because the policy was one that was created through a process, and the part of it was found to be illegal, but it was created through a process that was legal. So in that case, they created a policy. They created it through a lawful process. Part of it was found to be unlawful for other reasons. And then what they said is, oh, we're going to strike down the whole thing. And the court said, no, you can't do that because you created the entire policy because of severability. This is pretty common, right? Severability is pretty common legal principle. So unless you can always take away severability because you can do it in the rule or you can do it in the statute, but normally you want the option. So or a contract. Normally severability is the rule. So normally you say, and if you don't say, it's assumed to be true. So if you don't say it, you're assuming that you want severability, but often you say it. If you don't want severability, you have to say it explicitly. That's normally how this is done. But what it basically says is, if for some reason part of this contract or this rule or the statute or whatever it is, if part of this is found to be illegal, the rest remains legal, right? So that's a very common clause to see in a contract, regulation, rule, statute, whatever. Okay, where we allow for severability. And what happened is there was a rule passed through a process, and a court found part of it to be unlawful. And they also found severability, which again is not unusual. Courts will try to sever if they can. They can't always do it. So sometimes so much of it gets stricken down, or Central Park gets stricken down, or sometimes you can't save parts. So you try, but you can't always do it. But if you can, you try. And they were able to, and they found a way to sever it. And it's like, okay, great. And then the agency said, well, we're going to take away the whole thing. And said, no, you can't do that. You created it through a formal process. Part of it was created lawfully. Part of it wasn't. But part of it was created lawfully. And so if you want to undo that because the other half is now not valid, you can do that. We found it to be severable. But if you think it's not severable, you can do it. You just have to do it through a formal process. That makes total sense. It would be the same as if Congress passed a statute. So if Congress passes a statute and part of it's struck down and the other part remains, if Congress wants that part gone, they can repeal it, but they actually have to go through the effort of doing it. Otherwise, it remains valid. Same in a contract. Like, if you want to remove it, that's fine. You can do it. You just have to actually do it, right? So, but this all doesn't make sense because in that case, the rule that was created was one that was created lawfully. And so, yes, the whole thing is valid. Now, part of it's invalid. Okay, well, the remaining part's valid. Now we want to strike down the whole thing. No, you can't do that unless you go through a formal process. But here, that didn't work because none of it was created through a formal rulemaking process. So the part that was invalid was never created through a formal rulemaking. The part that was valid is just something we get to do on a whim because we're the prosecutor and it's part of our inherent power. So we can do or not do that at any time, our call. And the other part was never legal in the first place. And the court says, well, part of it's illegal, but part of it's not legal. It's like, yeah, but the part that's legal is something I could do. And the other part's something I can't. And I can also change my mind. And okay, never mind. Okay, pressing on. Yeah. Someone in chat pointed out the Affordable Care Act decision is way more logical than this. I mean, the Affordable Care Act has its own problems in terms of the rationale. You can get there. One of these days, maybe I'll discuss it in more detail, but this makes no sense. While the Department of Homeland Security was not required to consider all policy alternatives, deferred action was in the ambit of existing policy. Indeed, it was the center of of the policy, and failing to consider the option to retain deferred action failed to supply the requisite reasoned analysis. But he did not only did he consider it, he in fact did it. He did continue deferred action. It was part of the wind down. So not only did he consider it, he in fact did it. Okay. That omission alone renders Duke's decision arbitrary and capricious. My brain is going to explode any moment now, I'm telling you. But that was not the only defect. Duke also failed to address whether there's legitimate reliance on the DACA memorandum. Which, again, no, he did. He did, in fact, consider that. He said that, like, if you're within 6 months, you can apply for an extension again. And if not, then you're getting exactly as much as we promised you. You have reliance, even if it's the only extent of your reliance. I mean, the Obama administration never promised you tomorrow. The Obama administration promised you 2 years. That was it. And then you could reapply and reapply and reapply. So the Obama administration never promised you tomorrow. They promised you 2 years. And so the Trump administration said, well, maybe it was illegal, but these people relied on it. And again, in normal prosecution world, this kind of argument might make sense. It makes a little less sense in an ongoing violation, but let's look past that issue. But it says, we're going to let you, if you're within 6 months, reapply for another 2 years because you don't have enough time to wind down. And if you're more than 6 months out, we're only going to give you as much as you promised. You were never promised tomorrow anyway, but we're going to give you as much as you were promised, even though that promise was no good. So not only did the Department of Homeland Security, in fact, consider it, they did it, but let's look past that issue because I don't know. Certain features of the DACA policy may affect the strength of any reliance interests, such as the fact that we only guaranteed you 2 years at a time, maybe that feature. But those features are for the agency to consider in the first instance. Okay. Department of Homeland Security has flexibility in addressing any reliance interests and could have considered various accommodations. Which they did, incidentally. They did consider additional accommodations. We've been discussing them for a little bit now. While the agency was not required to pursue these accommodations, it was required to assess the existence and strength of it and weigh them against competing policies. Its failure to do so was arbitrary and capricious. The Chief Justice, joined by Justice Ginsburg, Breyer, and Kagan, concluding in Part 4, the respondent's claim failed to establish plausible inference recession was motivated by animus. Wow. I can't even believe I'm reading this. Oh my God. All right. Well, plus news on Plus News, my admiration for Justice Sotomayor continues to grow. So yes, apparently I'm becoming a Justice Sotomayor fanboy on a daily basis because Justice Sotomayor didn't join Part 4. Wow, I can't believe the Chief Justice joined that. Wow. Okay, my mind is a little bit blown, so I'm gonna read that again and then explain it to you. All right, so the Chief Justice. Okay, the Chief Justice, Justice Ginsburg, Justice Breyer, and Justice Kagan, but not Justice Sotomayor. Justice Sotomayor comes through again to uphold. So I become a Justice Sotomayor fanboy again a little bit. So not Justice Sotomayor, but 4 other people. 4 people concluded in Part 4. The respondents failed to establish a plausible inference of rescission was motivated by animus. Okay, and then Roberts delivered the opinion as except for Part 4 and blah, 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 whatever. Great. All right, so Yeah. So yeah, no, Alito, Thomas, Kavanaugh, and Gorsuch are in the minority opinion. But I'll give Sotomayor some credit for what we have. So, animus is hatred. Animus is hatred. So, yeah. So not only did we act arbitrary and capriciously, which is bad, we did it with specific animus. We did it with specific hatred of them, which would violate the Constitution too. Okay. Well, this decision's pretty crap. I need to wash the taste out of my mouth a little bit. Let me see if I can find Justice Thomas's opinion and just read the first part of it. We won't do the full thing because I don't have time. All right, so we'll read a little bit from the dissent. Justice Thomas, Alito, and Gorsuch write a dissent, and I think Kavanaugh wrote separately as well, but whatever. Between 2001 and 2011, Congress considered over 24 bills that would have granted lawful status to millions of aliens who were legally brought to this country as children. Each one of these efforts has failed. The Constitution is pretty clear that Congress gets to control immigration policy, so, go to Congress seems like a good idea, but all right. In the wake of this impasse, the Department of Homeland Security under President Barack Obama took matters into its own hands. Without any purported delegation of authority from Congress, and without undertaking rulemaking, Department of Homeland Security unilaterally created a program known as DACA. I didn't think an administrative agency could do this. Apparently they can, somehow. The 3-page DACA memorandum, which tells you everything you need to know right there, because formal rulemaking takes a little bit more than 3 pages. So yes, we basically did it on the back of a cocktail napkin. It was a long cocktail napkin, but, if you unfold a cocktail napkin, you can probably get 3 pages of text worth onto that. So yes, we unfolded a cocktail napkin, and we did it at a bar sometime. Yeah, that's great. The 3-page memorandum made it possible for approximately 1.7 million illegal aliens to qualify for temporary lawful presence, and certain benefits, somehow. When President Donald Trump took office in 2017, his acting Homeland Security, acting through another memorandum, rescinded that memorandum. Yeah, I'm with Justice Thomas immediately. The Obama administration did this on the back of a napkin. Why can Trump not do this on the back of a napkin? What's good for one administration should be good for another, right? So if the Obama administration can do this on the back of a cocktail napkin, why can't the Trump administration do it on the back of a cocktail napkin? Reasons. Okay. To state it plainly, the Trump administration rescinded DACA the same way it had been created. Yeah. Today, the majority makes the mystifying determination that this rescission of DACA is unlawful. It's a little mystifying to me, too. In reaching that conclusion, the majority acts as though it's engaging in routine application of standard principles of administrative law. They do a little bit, yes. On the contrary, this is anything but standard administrative law. Yeah, we're in some sort of new world. We're apparently in a world where we can create administrative law with a memo. All right, somehow that makes sense. The DHS created DACA through the administration without statutory authorization, without going with rulemaking or following the APA. As a result, the program was unlawful from its inception. At least half of it was, yeah. The majority does not even attempt to explain why a court has the authority to scrutinize an agency's policy reasons for rescinding an unlawful program. Yeah, majority. Why do I have to review this with any sort of skeptical eye when it wasn't created with a formal process in the first place. I don't know, I just do for some reason. The decision to countermand an unlawful agency is clearly reasonable, no joke. So as long as the agency's determination of illegality is sound, our review should be at an end. Well, I might write that a little bit more strictly than Thomas did. I might not write it quite that way, because that says, oh, well, the agency's determination of unlawfulness should be guiding, which again is giving too much credit to the administrative state, because that's like a little Chevron-esque, and I don't want to do that either. So I write this a little stricter than Thomas. I wouldn't say, oh, we should defer to their determination. I wouldn't do that. But what I would say is, yeah, it was in fact unlawful, and therefore they shouldn't be bound by that. So, like, their determination unlawful wouldn't do it for me, but it was unlawful, so, you know. Today's decision must be recognized for what it is, an effort to avoid a political controversy, but legally correct decision. Yeah, The court could have made clear the solution respondents must seek must come from the legislative branch, or even hypothetically through formal rulemaking somehow. Although the Fifth Circuit said it was in violation of the INI. So formal rulemaking wouldn't work because a formal rule can't violate a statute. So formal rulemaking also wouldn't work. So yeah, you'd have to go to Congress or get a napkin. Congress or a napkin. We are now in a position where your choices are Congress or a napkin. That's great. Instead, the majority has decided to prolong the Department of Homeland Security's initial overreach by providing a stopgap measure of its own. In doing so, it has given the green light for future political battles to be fought in this court rather than where they rightfully belong in the political branches. Such timidity forsakes the court's duty to apply the law according to neutral principles, and the ripple effect of the majority's error will be felt throughout our system of self-governance. Yeah, I'm already feeling it. I'm feeling it a lot. I feel we're doing law by napkin now, guys. It's law by napkin time. Perhaps even more unfortunately, the majority's holding creates perverse incentives, particularly for ongoing administrations. Under the auspices of today's decision, administrations can bind their successors by unlawfully adopting significant legal changes via napkin. Thank you, Cody Sams, for the super chat. Even if the agency lacked authority to effectuate the changes cannot be undone by the same agency in a successor administration unless the successor provides a sufficient policy justification. In other words, the majority erroneously holds an agency is not only permitted, but required to continue an unlawful program that's inherited from its administration. I respectfully dissent. Okay, well, so, yeah. So, I'm afraid I must inform you that we were all misled by Schoolhouse Rock. You know, it is no longer I'm just a bill. I'm only a bill standing here in Capitol Hill, waiting for Congress to pass me. No, now what we've got is I'm a napkin sitting in a holster at a bar, and some executive comes in and starts writing on me. And now I'm formal policy that can't be rescinded without rulemaking. I'm binding administrations through my alcohol-stained presence because I'm napkin at a hotel bar, and now I'm guiding principles, and I'll be put into the federal archives because I'm part of official law. It needs works on the lyrics, but you know that's what we got going on here. So this is wow. This is wow. Okay, that's a lot. My mind cannot fully comprehend all that. You know, I can get behind a lot of stuff. I can get behind the one where they struck down the census decision. I can get behind the gerrymandering case. I can even get behind Robert's opinion in the Affordable Care Act. I know he gets a lot of crap from conservatives, but I can make it work. You know, I can make that work, but I can't make this work. This doesn't make any sense. This doesn't make any sense to me at all. I can bend my mind into pretzels, but I can't make my mind bend into this pretzel. I can't understand the rationale of the majority decision. It doesn't make any logical sense to me. It doesn't seem to comply to any principles of law that I recognize. I don't get this. This makes my brain hurt. I don't understand. Please make the pain stop. Please make the pain stop. I want to live in a world where things make sense. That'd be great. I like to live in a world where things make sense and not and preferably not napkin world. I don't really like napkin world that much. But you know, if there was a law by napkin act passed by Congress, that'd be something. But can Trump administration just refuse to fund DACA? I mean, no. Um, the executive is bound to spend money the way Congress wants, and presumably they have to keep this running. And okay, Q Square gives me $5. Says Scott, the Supreme Court is right as their last word, not the last word because they're right. May always be overturned, so as long as they aren't too starry eyed. Yeah, but I like decisions that make sense, and I like decisions that flow from principles of law, and I like to, as a legal educator, explain to you like why decisions make sense, even if you don't agree with me. I like to explain to you with a logic flow that's like, well, here's some premises, and here we follow these through, and here's how that this works, and blah blah blah. Here's the logic chain, and I'm left like I don't understand. And Justice Thomas is writing, I was like, I don't understand. I'm like, yeah, I'm with you, Justice Thomas. I'm not getting it, man. And Congress never authorized DACA. Yeah, that's fair, but I mean, yeah, he has to keep it running. He has to keep it running because yeah, he would have to spend money to keep it running. So presumably, Department of Homeland Security has some sort of discretionary spending. So presumably, we're required to spend that money now. So yes, we have to keep spending money. So because we can't not spend money because we have to keep the program going. Uh yeah, this is really messed up. I don't really get this one. All right, well, for the 80 of you who are currently watching, I hope you liked the stream, if not the decision. If you like the stream, if you'd be so kind as to give it a like with your little thumbs up button, that would be helpful. If you've not already done so, if you'd subscribe, I want to thank the now 8,000 of you who are now subscribers because we just passed that milestone. So that's encouraging. I'm very excited about that. And I want to thank all of your participation and your super chats and all that stuff. Thank you, Q Squared, for the $2 super chat. So, Uncivil Law, I shared your video Richard with people as explanation events. They responded by saying you're just a patent lawyer. Do you think that disqualifies you from comment? I mean, not particularly. I have expertise in areas and not expertise in areas, but saying I'm just a patent lawyer is appeal to authority, right? So because I lacked the requisite credentials, I don't have the ability to speak on an issue. But I do, of course, have an underlying JD. I did go to law school, and I've been a lawyer for 12 years, and I cover quite a lot of cases on this channel that are not in my field. In fact, pretty much everything I cover on this channel is not in my field because it's a way to continue expanding my horizons and knowledge base. I find my field a little bit boring legally because I understand it so well. So, I've been doing this for a year. I read cases from all over the place. So I have a pretty solid knowledge base at this point because I read cases from every possible legal area, and I have an underlying legal knowledge to give a legal opinion. And so, I think saying like I'm just a patent lawyer, first of all, it's harder to be a patent lawyer because you have to have special credentials to be a patent lawyer, but there's that. But secondly, it's like, well, I've looked at the evidence and I've looked at the relevant law and I've done the analysis, and I don't think it's that hard. So, I mean, If someone wants to provide a legal analysis or factual analysis as to why I'm wrong, then okay. But I think saying, "Well, you're just a patent lawyer," is a little bit odd. You don't have the requisite credentials to interpret the law and explain it to us. And I'm like, well, I'm looking at the video, and it went on for 40 minutes, and the guy is running away, and now the taser is being pointed directly at the police officer's face. I'm not sure how being a patent lawyer disqualifies me from noting that, but okay. You know, good times. Yeah, yeah. Yeah, one of the reasons I really, really like this channel personally is because I read so many cases outside my field. And it makes me infinitely well educated. Well, not infinitely well, but very well educated, because I'm reading decisions from so many different fields of law. And so I'm more familiar with. It's like studying for the bar again. It's like being in law school again, because when you're in law school, you're reading cases from everywhere. Or when you're studying for the bar, you're reading for cases from everywhere. So it's like being in law school again. It's like studying for the bar again, and I'm reading cases from everywhere. So it's really, really fun. I really enjoy it. Yeah. So really good time. Anyways, I have to get ready for an improv thing. And so I might make a post later today and share that with you. I'm doing a murder mystery in 2 hours. And so I'm going to try to get into characters for the next 2 hours and get that ready to go. So I'm going to do that on Zoom. I am playing two characters. I'm playing Jack from Jack and the Beanstalk and Rumpelstiltskin in a murder mystery where I don't know who the murderer is. And it might be me, or it also might be me, because I'm playing two characters. So we'll find out. So that'll be fun. And we'll figure out how that goes. Until later, my friends. Peace and goodbye.